Hello friends, today in this session we will discuss an important topic of constitutional law, which is freedom of religion, in which we will discuss the cultural and educational rights of minorities. The brief highlights of today's topic are to know the rights of minorities under the Indian Constitution, to ascertain the meaning of minority, to know the relationship between Article 29 and Article 30, to determine the scope of Article 29 and Article 30 in light of judicial decisions, and to understand the role of judiciary in protecting the rights of minorities. Dear students, the founding fathers of the Indian Constitution enshrined in the Constitution ideals that sought to ensure for all citizens of India the equal opportunity to develop by securing for them social, economic and political justice, liberty of thought, expression, belief, faith and worship, and equality of status and opportunity. They are essential for establishing a society wherein people have the opportunity to enjoy the whole range of human rights within a cohesive and stable framework. In order to achieve unity and integrity of the country and to allay any fears of the minority communities, Article 29 and Article 30 were provided as protection against cultural hegemony of the dominant groups. Furthermore, Article 350A established that, I quote, "It shall be the endeavor of every state and of every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups." Quote end. The basic aim of these articles is not only to provide a better structure of the education for the minorities, but also to help us achieve secularism in the true sense. Dear friends, let us have a look on the genesis of constitutional protections of minorities. The founding fathers of the Constitution tried to satisfy the hope, aspiration and desire of the minority by safeguarding the educational rights of the minority. At the 5th session of Constituent Assembly of India, Dr. Rajendra Prasad assured the minorities that, I quote, "To all the minorities in India, we give the assurance that they will receive fair and just treatment and there will be no discrimination in any form against them. Their religion, their culture and their language are safe and they will enjoy all the rights and privileges of citizenship and will be expected in their turn to render loyalty to the country in which they live and its constitution. To all, we give the assurance that it will be our endeavor to end poverty and squalor and its companions, hunger and disease, to abolish distinction and exploitation and to ensure decent condition of living." Quote end. Indian democratic setup and constitutional safeguards respect the rights of minorities, and it has been placed under the Article 29 and Article 30 in the Part 3 of Indian Constitution. Through the perusal of the Constitution of India, it is found that expression minorities has been employed only at 4 places in the Constitution of India. Head note of Article 295 used the word minorities. Then again, the expression minorities or minority has been employed in head note of Article 30 and subclause 1 and 2 of Article 30. At this stage, it may be noted that the expression minorities has been used in Article 30 on 2 senses, one based on religion and other based on language. Friends, let's have an answer for the question, what is a minority? Though the word minority has not been defined in the Constitution, the Motilal Nehru Report 1928 showed a prominent desire to afford protection to minorities, but did not define the expression. The Sapru Report 1945 also proposed inter alia a minorities commission, but did not define minority. The United Nations Subcommission on Prevention of Discrimination and Protection of Minorities has defined minority as, the term minority includes only those non-documented group of the population which possesses and wish to preserve stable ethnic, religious or linguistic traditions or characteristics markedly different from those of the rest of the population. Such minorities should properly include the number of persons sufficient by themselves to preserve such traditions or characteristics, and such minorities should be loyal to the state of which they are nationals. The National Commission of Minority Educational Institutions Act 2004, as amended time and again in 2006 and 2010, for short the Act, has been enacted to safeguard the educational rights of the minorities enshrined in Article 30, Clause 1 of the Constitution. The Act defines minority under Section 2, Clause F as for the purpose of this Act means a community notified as such by the central government. Furthermore, as regards the indica to be prescribed for the grant of minority status certificate, a reference to Section 2, Clause G of the Act has become inevitable as it defines a minority educational institutions. Section 2, Clause G is, I quote, minority educational institution means a college or an educational institution established and administered by a minority or minorities, quote end. The initial courtroom attempt to answer the first question of defining minority has been made in Re-Kerala Education Bill, where the Supreme Court through Chief Justice S.R. Das, suggesting the techniques of arithmetic tabulation, held that the minority means a community which is numerically less than 50% of the total population. This statistical criterion prevailed with the Kerala High Court also, which is in A.M. Patroni versus Case 1, defining minority to mean the same thing as it meant to the Supreme Court. In the Guru Nanak University case, the Supreme Court rejected the contention of the state of Punjab that a religious or linguistic minority should be a minority in relation to the entire population of India. The court has ruled that a minority has to be determined in relation to the particular legislation which is sought to be implemented. If it is a state law, the minorities have to be determined in relation to the state population. In T.M.A. Pai Foundation case, the 11 judges bench of the Supreme Court confirmed the position that minority status of a community is to be decided with reference to the state population. Dear students, let's understand the scope of Article 29 and 30 in light of judicial decisions. Article 29 reads as, Clause 1, any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. Clause 2, no citizens shall be denied admission into any educational institution maintained by the state or receiving aid out of state fund on ground only of religion, race, caste, language or any of them. And Article 30 reads, Clause 1, all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. Clause 1a, in making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority referred to in Clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under clause. Clause 2, the state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of minority, whether based on religion or language. The Supreme Court of India, while interpreting the scope of Article 29 and 30 of the Constitution in Re-Kerala Education Bill case, held that the right to establish and maintain educational institutions of their own choice is necessary concomitant to the right of minority to conserve their distinctive language, script and culture through educational institution. The right under Article 30 Clause 1 is subject to Clause 2 of Article 29, which provides that no citizen shall be denied admission into educational institution maintained by the state or receiving the aid out of the state fund on the grounds only of religion, race, caste, language or any of them. The court, after reviewing its earlier decisions, held in case of St. Xavier's College v. State of Gujarat that Article 29 Clause 1 and Article 30 Clause 1 deal with the distinct matters and may be considered supplementing each other, so far as certain cultural rights are concerned. Article 30 Clause 1 covers institutions imparting general secular education. The objective of Article 30 is to enable children of minorities to go out in the world fully equipped. If Article 29 and 30 are grouped together, it will be wrong to restrict the rights of minority to establish and administer educational institution concerned with language, script and culture of the minorities. The reasons are, firstly, Article 29 confers the fundamental rights on any section of the citizen, which will include the majority also, whereas Article 30 Clause 1 confers all rights on all minorities. Secondly, Article 29 Clause 1 is concerned with language, script or culture, whereas Article 30 Clause 1 deals with minorities based on religion or language. Thirdly, Article 29 Clause 1 is concerned with the right to conserve language, script or culture, whereas Article 30 Clause 1 deals with the right to establish and administer educational institutions of the minorities of their choice. Fourthly, the conservation of language, script or culture under Article 29 Clause 1 may be by means wholly unconnected with the educational institutions, and similarly, establishment and administer educational institutions by a minority under Article 30 Clause 1 may be unconnected with any motive to conserve language, script or culture. A minority may administer an institution for religious education which is wholly unconnected with any question of conserving language, script or culture. It may be that Article 29 Clause 1 and Article 30 Clause 1 overlap, but the former cannot limit width of the latter. The scope of Article 30 rests on the fact that right to establish and administer education institution of their choice is guaranteed only to linguistic or religious minorities, and no other section of citizens has such a right. Further, Article 30 Clause 1 gives the right to linguistic minorities irrespective of their religion. It is therefore not at all possible to exclude secular education from Article 30. Aziz Basha versus Union of India is a very important decision on the right conferred by Article 30 Clause 1 on linguistic and religious minorities to establish and administer educational institutions. The petitioner impugned the validity of Aligarh Muslim University Amendment Act 1965, which amended the Aligarh Muslim University Act 1920, the Act of 1920, on the ground that the amendment deprived the Muslim minority community of its right to manage the university established by the community, according to which members of the court had to be Muslims. The amendment had not been challenged because, in fact, the setup of the university had continued unchanged. The effect of the amendment was that the court ceased to be the supreme governing body of the university, and it was not necessary that it should consist exclusively of Muslims. The Supreme Court held the very expression established and administered used in Article 30 Clause 1 was to be read conjunctively, that is to say, two requirements had to be fulfilled under Article 30 Clause 1, namely, that the institution was established by the community and that its administration was rested in the community. The court went into the meaning of the word established, and after referring to various dictionary meaning, it said that the word founding is not the only meaning of the word establish, but it also means to bring into existence. Therefore, the right given by Article 30 Clause 1 to the minority is to bring into the existence an educational institution, and if they do so, to administer it. Keeping this concept in view, the court examined the history of the Aligarh Muslim University, and notwithstanding the fact that it was clear that it was a Muslim minority that made an effort, collected the money and handed over the properties of the Mohammedan Anglo-Oriental College and those of the Muslim University Association, the university in fact owed its birth to the Aligarh Muslim University Act, and that it was not brought into existence by the Muslim minority community. The court observed that it could not be said that the university was established by the Muslim community because the provision of the Section 6 of the Act of 1920 that the degree conferred by the university would be recognized by the government. It showed that the Aligarh Muslim University, when it came to be established in 1920, was not established by the Muslim minority, for the minority could not insist on the recognition by government of the degrees conferred by any university established by it. In the recent case of Nargesh Agrawal versus Bharat, the Allahabad High Court held that AMU was not a minority institution. The court struck down the amendment made to the effect in the statute of AMU for reservation to the Muslim students. The court followed the Aziz Basha versus Union of India case rulings in the case of S.K. Patru versus State of Bihar. The Honorable Supreme Court held that the mere fact that funds were obtained from abroad for assisting in setting up and developing the school which was established by the minority in India, or that its management was carried on at times by some person who were not born in India, could not be ground to deny to it the protection of Article 30 Clause 1. In the case of State of West Bengal versus Guru Nanak Educational Trust, the court held that it may be even by a single philanthropic individual with his own means in the interest of minority community. In the case of State of Kerala versus Mother Provincial, the court has said the following points. I quote, "It matters not if a single philanthropic individual with his own means found the institution or the community at large contributes the funds. The position in law is the same, and the intention in either case must be to found an institution for the benefit of a minority community by a member of that community." Quote end. Article 30 gives right to the minority as such and not to an individual member, and the rights are meant to benefit the minority by protecting and promoting its interests. There should be a nexus between the institution and the particular minority to which it claims to belong. A considerable section of the minority must be benefited by the institution. In Arya Samaj Shillong versus State of Meghalaya, the Guwahati High Court has held that the Arya Samaj Hindi Kanya Vidyalaya School in Meghalaya is a minority institution, and therefore the state has not power to change the constitution of the managing committee of the school. Arya Samaj in Meghalaya is both linguistic as well as religious minority. It has a distinct entity, hence it was held that the notification directing the school to follow instructions of the change of the constitution of the managing committee was unconstitutional and invalid. In the case of TMA5 Foundation vs. State of Karnataka, a question was raised. Is there a fundamental right to set up educational institution, and if so, under which provision? The answer of the court was, I quote, "With regard to establishment of educational institutions, 3 articles of the constitution come into play. Article 19, Clause 1, Subclause G gives the right to all the citizens to practice any profession or to carry on any occupation, trade or business. This right is subject to restrictions that may be placed under Article 19, Clause 6. Article 26 gives the right to every religious denomination to establish and maintain an institution for religious purposes, which would include an educational institution. Article 19, Clause 1, Subclause G and Article 26 therefore confer rights on all citizens and religious denomination to establish and maintain educational institution. There was no serious dispute that the majority community as well as the linguistic and religious minority would have a right under Article 19, Clause 1, Subclause G and Article 26 to establish educational institutions. In addition, Article 30, Clause 1 in no uncertain terms gives the right to the religious and linguistic minorities to establish and administer educational institutions of their choice. Quote end. In the case of P.A. Inamdar vs. State of Maharashtra, the question was raised, can there be an inquiry to identify the person or persons who have really established the institution? With regard of this question, the Honorable Supreme Court has taken the proposition of TMA Pai Foundation vs. State of Karnataka. I quote, "Pai Foundation has clearly ruled in favor of the state or a province being the unit for their purpose of deciding minority. By this declaration of law, certain consequences follow. First, every community in India becomes a minority because in one or the other state of the country it will be in minority, linguistic or religious. What would happen if minority belongs to a particular state, establishes an educational institution in that state and administers it but for the benefit of members belonging to that minority domiciled in the neighboring state while the community is in majority? Would it not be a fraud on the constitution? In St. Stephen's College vs. University of Delhi, their lordships had ruled that Article 30, Clause 1 is a protective measure only for the benefit of religious and linguistic minorities, and no ill-fit or camouflaged institution should get away with the constitutional protection. The question need not detain us for long as it stands answered in no uncertain terms in Pai Foundation, emphasizing the need for preserving its minority character so as to enjoy the privilege of protection under Article 30, Clause 1, it is necessary that the objective of establishing the institution was not defeated. Quote end. Except Aziz Basha case regarding minority institution, the court held that a person from minority community has set up the institution or the financial assistance coming from the minority community for setting up the education institution would be treated as minority institution. Article 29 deals with the concept of protection of the interests of minorities, and Article 30 says about the rights to establish and administer educational institution of their choice. In general, it can be said the scope of minority rights are to preserve the language, script or culture, 2. to establish the educational institution, 3. to administer educational institution, and to administer according to their choice. It can be said that a minority can preserve language, script, culture through the educational institution. But the right to minority education does not indicate religious teaching but general secular education. Generally established means coming into existence of an educational institution by the minority, and administer means day-to-day administration of the institution. The power of the administration has many facets like appointment of the teachers, admission of the students, choice to determination of language of educational institution, etc. The observation of the Supreme Court in Re Kerala Educational Bill, I quote, "The right conferred to minorities to administer educational institution of their choice is not an absolute right." Quote end. The minority education institution can be classified into recognized aided institution, recognized unaided institution, unrecognized institutions. The unaided minority institution is also subject to regulation of the government. The Honorable Supreme Court of India, by their judicial dictum, tried to interfere the letter and spirit of the constitutional provision regarding the minority right to education at this post-modernism and global era, keeping in view the recent socio-economical jurisprudential orientation and the new trend of unaided minority educational institution. To satisfy the new trend of liberalization, privatization and globalization, the intelligent judiciary in TMA 5 Foundation vs. State of Karnataka has overruled the view of Unni Krishna that the nationalization of education and surrendering the process of selection to the state, but TMA 5 Foundation allowed to education institution to generate a reasonable surplus to meet the cost of expansion and augmentation of facilities, who would not amount to profit. In case of Islamic Academy vs. State of Karnataka, the ratio of Pi Foundation that autonomy of unaided non-minority institution is an important facet of their right under Article 19 Clause 1 Subclause G, and in case minority under Article 19 Clause 1 Subclause G read with Article 30 of the Constitution has been ignored. The effect of putting together the Article 29 Clause 2 and Article 30 Clause 1 reduces the benefits promised to the minorities through Article 30. It is true that Article 29 Clause 1 and Article 30 Clause 1 overlap, but the former cannot limit the width of the latter. The scope of Article 30 rests on the fact that right to establish and administer educational institution of their own choice is guaranteed only to the linguistic or religious minorities, and no other section of citizens has such a right. We can thus conclude that it is appropriate time for the Parliament to define the term minority and the scope of Article 30, so that time and again the right granted to minorities under Article 30 to establish and administer educational institutions should not be put to the tests of judicial interpretations. Dear students, that's all for today. Hope you would have understood the cultural and educational rights of minorities under Indian Constitution very well. Goodbye and stay blessed.